Good afternoon to everyone. Today, on behalf of Department of Psychiatry and the Student Counseling Center of Chettinad Academy of Research and Education, I welcome you all for this commemoration of International Day Against Drug Abuse and Illicit Trafficking. On the occasion, we have a special speaker from our School of Law, Ms. Mrinalini, to give us an insight about the laws governing these the drug abuse and illicit trafficking. So before going further, I just want to give you a brief introduction about the International Day Against Drug Abuse and Illicit Trafficking. It is being commemorated every year on 26th of June by the United Nations Organization Against Drug Use. Previously, it was known as World Drug Day, and the theme of the current year 2020 is Better Knowledge for Better Care. So no wonder that we aspire for better knowledge regarding the laws governing international law against the drug abuse and illicit trafficking for us to give us a better care for our patients. The field of addressing the drug abuse problem has been plagued by misinformation of many kinds. The year's theme aims at improving the understanding of the world drug problem and fostering greater international cooperation for countering the impact of drug menace on the health, governance, and security. The UNODC encourages the individuals, non-profit organizations, private sector, and member states to get involved in this campaign against illicit trafficking and drug abuse. As you are aware, the UNO has given us an estimate of 35.6 million people across the world being the victims of drug abuse. It is the latest World Drug Report published by the UN Office on Drugs and Crime in 2020. And the problematic aspect is the young adults and the teenagers, they account for the largest share of those using drugs. And one more problem is, in addition to drug, they become victim of illnesses like HIV, hepatitis C, and other related illnesses. So UN tries to reach out to people, non-profit organization, and countries against this drug abuse, illicit trafficking. It started in 1987 by the UN General Assembly, and it was decided June 26 to be the day of National Day Against Drug Abuse and Illicit Trafficking. So with this introduction, I will give the session to Dr. Shabiba Kailash, who will be chairing the session. Over to Dr. Shabiba.
Thank you, Dr. Shabari. Yeah, so I again welcome you all who have joined us this noon for the session on the occasion of International Drug Abuse Day and Illicit Trafficking. So I am deeply delighted to welcome Ms. Mrinalini Banerjee, Assistant Professor, Chettinad School of Law, to give us a deep insight about the legal aspects of drug abuse and illicit trafficking with a profound knowledge in her field. Ms. Mrinalini Banerjee is currently working as an Assistant Professor at Chettinad School of Law. Before joining us, she was working with G.D. Goenka University at Gurgaon. She graduated from the School of Law, KIIT University, specializing in International Law Honours. She subsequently completed her Master of Laws from King's College London, focusing on translational law. She was the recipient of the Goodenough Commonwealth Scholarship 2016. Presently, Ms. Banerjee is pursuing her PhD from Gujarat National Law University. Has qualified both UGC, NP, and AIB. Apart from this, she has completed an academic course from SOAS, University of London, and completed private international law course in 2017 at the Hague Academy of International Law, Netherlands. She is also the recipient of the GAJE 2019 scholarship and received grants from Asian Development Bank and IUCN Academy of Environmental Law to participate in a train trainers workshop and present her paper in Colombo and Kuala Lumpur respectively. Ms. Banerjee has contributed by publishing her views on various topics pertaining to international law and other contemporary social and legal issues in various journals. She has also presented papers in various national and international seminars and conferences on a varied subject like international humanitarian law, women justice, environmental law, etc. I take pleasure in welcoming her to give this oration. Over to you, ma'am.
Thank you so much, ma'am, for your generous introduction. Before I begin, I would firstly want to thank Dr. Sridhar, who made an effort to connect to time. And I would also like to share the thanks to the entire department who have been working so hard to come up with this day. So before I proceed further, I would first like to give a little introduction. Then I will speak on the international conventions which prohibit drug abuse and illicit trafficking, and then we'll come to the Indian perspective. So coming to the drugs addiction, as we all know, and you all being all doctors or upcoming doctors, you all better know than me what is the medical effects of or medical harms that happen by usage of drugs or overuses of drugs. If I see drugs as an addiction and it has been very expensive, if I may quote Hindustan Times, which clearly said that 1 kg of heroin is worth of 6.5 crores. So when I can see a drug which is very expensive, obviously there would be illicit trafficking of that drugs. Why illicit trafficking? For two reasons. Number one, it's not in the market, it is very expensive. So for these two reasons, when the need, the demand of the drug is too high, you can expect that there has been illicit trafficking. Moreover, what has been found out, the statistics is that the drugs addicted group is mostly from 18 to 35 years. And it's been found that in the market, the drug consumption is very high when it comes to India. India is one of the highest drugs consumption demand in the market. The various ways of taking up these drugs, which I could figure out, are three mainly which are being done, are smoking, injection, and snorting. And it depends from case to case and person to person how they take it. So before I again proceed with the introduction,
Excuse me,
am I audible?
Mrinalini, ma'am.
Yes, ma'am. Am I audible?
Do you have any PowerPoint or anything to share, or?
No PowerPoint.
Okay,
As such.
okay, ma'am.
Send my materials after this lecture so you can distribute with your students also. What
Okay,
I can do.
sure. Yeah.
Thank you. Coming to the international convention, the very first international convention was the single convention on narcotics drugs, which was introduced in 1961. And this treaty prohibited two things. Number one, the production, and number two was the supply of what? Again, two specific drugs and drugs with similar effects. What was the exemption that has been given to this drug was that any drugs which was being used for the purposes of medical treatment and research were allowed. Apart from that, any drugs which was being procured or was being used, sold, or kept or in possession was completely prohibited by this 1961 convention. This convention is very important because this also updated the Paris Convention of the 13th July 1931 to include the vast number of synthetic opioids. Initially, there was a convention in 1931. As days pass by, as we can know, like before we never had coronavirus, but now we have a new category of virus, which is called the coronavirus, which we are still struggling to find the vaccine for it. For example, there were very less number of drugs in 1931, but it gradually increased when it was 1961. So this convention listed all those drugs into that and prohibited the usage and the supply and even the procurement of such drugs. Apart from this, I would now say, what is the need for this single convention 1961? The earlier treaties only controlled opium and coca, which are the derivatives of morphine, heroin, and cocaine. only controlling was not helping, because as we see, this international community, the international market is very dynamic. And with every new invention or usage of a drug, things have started developing a worse thing. There has been a lot of drug abuse. So this 1961 convention listed all those things in a very systematic manner and started prohibiting it. Not only this, the single convention was a broadened convention. It broadened the scope of drug abuse and included cannabis and the drugs which are similar to the drugs specified, which was very important because there were many other drugs which may not be mentioned, but if you write in legal perspective that drugs of similar specified, then it includes all the drugs of similar generic into that legal perspective. Apart from this, the Commission of Narcotics, Drugs and the World Health Organization was empowered to add, remove, and transfer drugs into the specified 4 schedules to control the substances and drug abuse. The convention was clearly classified into 4 schedules. Each schedule specified various drugs and for various purposes. So according to the need of the international community, according to the requirement, there were 2 departments which were formed, the WHO and the Commission on Narcotics Drugs. They used to interchange, remove, add according to the demand in the market. The International Narcotics Control Board was put in charge to administer and also to put a control on the drugs production and its trading. There's a huge trade market that is there, which includes drugs. Not only don't we, being lawyers, we cannot see it in a smaller perspective, because along with drugs, there is also immoral trafficking. That means humans are also being trafficked, who are being the victims of carrying these drugs from one state to another state, from one country to another country. So one crime, if allowed, or if by chance been overlooked, it can pull into or it can drag another crime. So looking into the various aspects of it, they started, that means the International Narcotics Control Board, they put a strong control on drugs production and drugs trade. Why drugs production? Because if drugs is less produced, obviously it will be less sold in the market. If it's been less sold in the market, trading would automatically be low. So it's a chain. If I control the production, I can control the sale, I can control the trade, I can control this crime, and if I can control this crime, the various interrelated crime with this crime are automatically gets controlled. Now I come to the United Nations Office of Drugs and Crime, which delegated to control the board's day-to-day work of monitoring every country's usage of drug. There are various countries. Every country have their own laws. For example, India have its own law on drugs. Whereas if I say UK will have its own laws, US will have its own laws, our SAARC nations will have its own laws. But who is going to be looking after it? The UNODC would be looking after it, that how much drugs India is producing, or what is the usage of it. Because if that is being not allowed, there can be a country illegally practicing or producing drugs. And from that country, it can rampantly increase to a greater level. Not only this, it would also further compliance with the national authorities of every state. The use in international law, state does not mean Tamil Nadu, West Bengal, Kerala. State means, for example, state means it is like one country. For example, if there is the Convention of the United Nations, then every country is called a state party. What do we mean by state party? For example, right now I spoke about the 1961 convention. Any country who signs and ratifies that convention becomes a state party to that United Nations convention. So here state means every country. In international law is called as a state. And when you sign and ratify, you are being known as a state party to that UN convention. According to this convention, as I've already mentioned, there are 4 schedules which will be looking after the various drugs. Now I proceed to another convention, which is equally important to this 1961 convention. This convention on psychotropic substances was introduced on 1971. Again, it is an international convention. This was signed in Vienna, Austria, that is on 21st of February 1971. This convention was not contradicting the 1961 convention, neither was it rejecting anything, but it was complementing the 1961 convention. So if I may say, without 1961, there cannot be a 1971. Without 1971, there may not be a 1961. Because what is mentioned in 1961 has been also looked after, and many other things have been added into the 1971 convention, which is the Psychotropic Substances Convention. Apart from this convention's main role was to prohibit many drugs which was then not prohibited, then not come into the market in 1961. So as I can say that, as I have repeatedly told you, as the world is dynamic, things are introduced. 1931 convention got replaced by the 1961 convention. 1961 convention is now being working complementary with the 1971 convention. This convention also have 4 schedules, and there are various other drugs whose usage have been controlled and regulated in the 4 drugs according to the convention bodies. Who controls this? Who examines these drugs which are being mentioned here? The World Health Organization examines all the drugs which are being mentioned here. According to the Article 22 of this article, it is called the penal provision. Penal provision means it is the punishment that deals with it. Now, as per the international norms in the international community, coming to India, the theory that we follow in international law, if I cannot go to a court saying that I have violated the 1961 Convention Article 4, or neither can I go to the court saying that Article 7 of the, or Article 11 of the 1971 Convention has been violated. But then what can be done? It can be done that whatever laws have been mentioned in those international conventions, those will be imbibed and brought into our national law, which I will be dealing in the latter part. So what does this Article 22 of this 1971 convention says? It clearly specifies that the country, that means the state, has to punish if there is any illicit drug abuse offense been found, and that has to be done as per the country norms. Why as per the country norms? Because there are many countries which allow death penalty. There are many countries which doesn't allow death penalty. So depending on the country's norms, laws, rules, regulations, these penal provisions would be controlled, and it would be done as deemed fit. Apart from that, what Article 22 also mentions that the state needs to ensure that the abuser, if possible, can be going through the treatment, medical treatment. Here where I see your profession comes in, that there can be a law can be passed. For example, a judge can say, seeing the abuser, if it's not such a heinous crime has been crimed or a grave crime has not been committed, then he may say that, or it's a juvenile who has been doing it. Juvenile means it's not an adult yet. A juvenile has committed it. Then may say, you may go back to a reformer's house. Reformer's house means where you'll be reformed into a better human being, where you would be rehabilitated from all these drugs that has been imbibed into you, and you can go for education, you can go for treatments, you can go for pro prayers also. So 22 of this convention specifies both the things. So what are the two things? Number one, the punishment has to be done, but as per the state norms. Number two, only punishment is not allowed. I mean, it's not appreciated. Allowed is not a right word. It's not appreciated. So what is the result? It can be like, other alternative measures can be used. For example, education, as I've right now mentioned, they can go for treatment so that, like, for example, if I come to India, only punishment means punitive punishment. But if I go for reformative, obviously the person, if done a crime, needs to be punished. But along with that, if we can reform that person to be free from drug abuse, to be a better human being, according to human rights, it has been expected and thought a better justice has been delivered. So this is what Article 22 of the 1971 Convention speaks. Now I come to the third and the last most important international convention which deals with drug abuse. That is called the UN Convention Against Illicit Trafficking in Narcotics, Drugs and Psychotropic Substances. It was introduced in 1988. As per 2020, we have right now 191 state parties to this convention. That means 191 countries have signed it and ratified it. So when you have signed and ratified it, you are obligated, you are bound to follow all the rules and the regulations that are mentioned in this 1988 convention. Maybe your country does not allow you to go to the court as per the 1988. For example, in India, we cannot go to court by mentioning Article 4 or 16 or whatever of 1988. But yes, we need to make an Indian Act which will contain all the important things that are mentioned in this Act. Now, as per the Article 3 of this convention, it prohibits the possession of drugs for personal use. Now, there was a huge amount of debate with this Article 3 of the convention. Why there was a debate? Because there were some countries whose norms clearly specify that you can keep drugs, but in a limited amount with mentioning and taking license for your personal use. But Article 3 of this convention completely prohibits it. So the debate here is that which law to follow. Should I follow Article 3 of this convention, or should I follow the rule which has been mentioned in my country? In this category, if ever there is a conflict between a national law and an international convention, the national law will always override the international convention. So, after this huge debate that had come up, another point that has been mentioned with this point, that said that this Article 3 of this 1988 convention would be accepted till the extent it is not infringing any constitutional rights of that specific country. I'll give you an hypothetical example. So I again repeat, this is an hypothetical example. It is not true. For example, in India, we can keep weapons with license. Provided we have a license and norms, we can keep. But supposedly, tomorrow, if we ratify a convention which clearly prohibits the usage of any, supposedly prohibits that you are not allowed to keep any weapon for personal use, then it is completely contradicting with a law which has been specified in India. At that time, it will be decided whether we would accept that or we would accept this. But if there has been a lot of arguments, a lot of debates, and a lot of commotions, then obviously only the portion which is not infringing, or it is not anyhow not violating any constitutional right of that country, then that will be accepted. And the rest portion wouldn't be accepted. But only this has been done till Article 3 of the 1988 Convention. Coming in 2003, there was a proposal that was made by the European Parliamentarian Committee to recommend to repeal the 1988 Convention, but it is yet a proposal. The 1988 Convention is very much there. According to Article 30, individual nations can withdraw from the treaty. What do you mean by this? That means if I have once signed and ratified, does not mean that for lifelong that country needs to abide it. If country gradually, according to the socio-economic, political, legal, and various other aspects, looks into and sees that they cannot follow the rules mentioned in that convention, which they had once ratified, then they can withdraw themselves from that very convention. That right and that authority is also mentioned under Article 30 of this 1988 Act. So these are the three very important conventions which deals with the drug abuse and illicit trafficking, 1961, 1971, 1988. So this is the international scenario right now. There are many international regional scenarios. For example, in Europe, there will be different. In US, there will be different laws. In Afro countries, there will be different. In Latin American countries, there will be different. But we will be not looking into that. We'll be only looking into the UN conventions, which acts as a mother of all other conventions. Now I would come to India. If I come to India, we have the Narcotics, Drugs and Psychotropic Substance Act 1985. India got its independence in 1947. Then why did it take 1985 to come? As we can see that drugs have entered India way before 1985. But according to Indian getting independence, coping up with the new independence that they have got, into looking into the constitutional rights, the fundamental rights, the directive principles, yes, it took a little time for this act to come in. Initially, things were a little overlooked, but when things have rampantly increased, then yes, this act was introduced and it has been commonly said as the NDPS Act. These narcotic drugs include coca plant, opium, and cannabis. These are the three important things that they look into this. And this, as I have previously mentioned, that if we have signed and ratified the convention, we need to take it into this act. So this act is the amalgamation of the three conventions which I have mentioned below. So whatever are the drugs which have been mentioned in those schedules of 1961, 71 and 1988 convention would be included. What are the penal provisions been mentioned there? Those are also going to be looked after and obviously going to be included. But definitely, whenever we are including it, we need to keep in mind the socio-economic, legal, political and cultural and the various other aspects of the very country, which differs from one country to another country. So when we are doing it in India, we'll be looking after the Indian perspective. In 1985, NDPA Act was passed and it replaced the Dangerous Drugs Act of 1930. So as I have said that we had drugs abuse for a long period of time, but the 1930 Dangerous Drugs Act was completely obsolete when we see the 1985 Act. Along with this Dangerous Drugs Act, there was Drugs and Cosmetics Act 1940, which was not repealed. That means it was not, repealed means it was not kept set aside, or it is not even overlooked. It is still in India, we all still have it valid use of Drugs and Cosmetics Act 1940. But the Dangerous Drugs Act of 1930, it was been replaced by the NDPS Act of 1985. This 1985 Act was been amended 3 times. Amended means there has been an alteration. There can be addition, there can be subtraction, there can be just a portion being included to an act, or anyhow it can be altered. So this 1985 Act has been amended 3 times. 1989, 2009, 1989, 2001, and very recently 2014. And what does this act do? This act places a very, very strong restriction on 5 things. Number 1 is cultivation, number 2 trade, number 3 import, number 4 export, any other local consumption. Why in law we always use, like in this case, we use any other local consumption, so that in case we have missed out something, we can drag that into this perspective. So that in case anything, for example, maybe there is a local consumption of drug in West Bengal, which is not there in your state, but maybe the person who's creating this act or who's writing this act unaware of it. But if we write any other local consumption, that means even if we have not mentioned about it, we can include it into the act. So coming to chapter 4 of this act, which is a very important part, and I have only kept that part for today's discussion, it deals about fines and punishments. Fine and punishment are also being categorized into 3 categories. Number 1, small quantity. Number 2, more than small quantity. Number 3, commercial quantity. So coming to small quantity, we see 6 months of rigorous punishment or fine of 10,000 rupees or both. So if anybody has been found for usage of small quantity, then there'll be 6 months of rigorous punishment, or there can be fine, or it can be both. Now, who will decide this? The judge will decide this. So supposedly the question that can come to your mind is that, supposedly if I use drug hypothetically at a very less amount, the less amount is hypothetical and it is vague. It has no number of what is called less and what is called more than less, or what is called commercial. So it depends from case to case. If I have just used maybe one little bit of drugs, maybe I can be left with only fine. But if somebody has found with only 2 small packets of, probably that's a small quantity, 2 small packets of any drugs, then the judge may give them 6 months of rigorous punishment. If someone is maybe found with more than 4, or this is what I am saying, but it depends on the judge who sits there and the case and the scenario in which it has been found, then maybe the judge may ask rigorous punishment for 6 months plus 10,000 fine. So it depends from case to case, judge to judge, court to court. Maybe a punishment may differ. It is completely case to case basis. So now coming to more than small quantity but less than commercial quantity, the punishment is for 10 years of rigorous punishment, fine up to 1 lakh, or both. Again, as I have mentioned, it depends on case to case basis. Commercial purpose is for 10 to 20 years of rigorous punishment, or 2 lakh rupees, or it is of this act. Now coming to chapter 2 of this act, there are laws which are imposed on drug addicted and people to cure them and improve their health. So as I have previously mentioned, law looks into the reformative aspect of every person. It does not look into the only punitive punishment. Punitive punishment does not help. So chapter 2 specifically speaks about this cure and improvement. Coming to the significant aspects of the NDPS Act are 3. Coming to this 2014 amendment, as Rashi has very clearly mentioned, I was coming to that punishment also. Death penalty, which was initially introduced as compulsory in the previous amendment, in the 2014 amendment, death penalty was made discretionary. What do you mean by discretionary? It depends again from case to case basis. And an alternative punishment of 30 years was being introduced. Another thing that was being introduced was called the quality-based sentencing. What do you mean by quality-based sentencing? Quality-based sentencing means when a drug has been found, it will be weighted. Evidence would be seen. How it has been used will be looked into. The various other aspects would be looked into, and then the punishment would be then decided accordingly. And then it will be decided what kind of punishment would be given. Now coming to the treatment for drugs dependence. Initially, drugs dependence was something which was not there mostly in India, but now we have involved that thing to a greater extent. Now many a times what happens, what is written is never executed, because execution is completely not different, I would say, but implementation and execution doesn't go hand in hand. So when it goes hand in hand, so what happens, the treatment has now been more encouraged than punishment. So they would first see if, obviously, if the case is very huge, if there has been a racket that has been done, definitely punishment would be done. But otherwise, they would try to first see whether a reformative approach would be able to reform it or not. This is the three important significant aspects of the NDPS Act that has been mentioned. So apart from that, if you all have any questions, you all can ask me. I'm happy to answer you. And I would also, before I proceed, I would also say, as Rashi very well mentioned, according, even I can share the screen with you all. The new things that has been mentioned here in the chapter 4, the punishment, as we can see, for contravention, it depends from every case. For example, in poppy straw is different. For example, in cocoa plant and coca leaves, it's different. For example, if we see for opium, it's different, and different aspects it will be seen. And it varies, like again, if we see for opium, poppy and opium, it is different. So if I see this, along with that, we need to also keep in mind the usage of it, which is always been looked into the legal aspects. If somebody has been, if I may say, which is also very well mentioned in IPC as a general defense, that is the Indian Penal Code 1860, that somebody who personally may not wanted to be a part of this, but somehow became a victim of it, then the punishment for that person would be completely different to person who has been a principal person into this act, or the main perpetrator, who is a perpetrator for the person who has been involved into this case. They would be involved into it. For example, supposedly who unknowingly, unintentionally, these are the two very important aspects, unknowingly and unintentionally have been a part of this, for them the punishment would definitely be different. But then again, a word that has been used in IPC, which will obviously, in law, no act would be dealt only in that act. It may get connected, or may not even, obviously, but it may get connected with various other acts. For example, if abatement means somebody who's helping another person to run this such kind of drug abuse racket, would be equally punishable to that of the main perpetrator. This is what I wanted to specify. And anything else you wanted to ask me, you can ask me according to IPC or the NDPA Act. You can ask me.
Thank you, ma'am. So, yeah.
Ma'am, thanks a lot for such an enlightening as well as crisp brief to us about.
This act is itself very small. It has only very few sections into it. Whenever anybody, there have been many cases. I can deal a case. I can share a case with all of you. There's a landmark case in the Supreme Court of India. In that case, what happened? There are fundamental rights which every individual are given. That is part 3 of the Constitution. And one of the most important act is, for example, Article 14, that is right to equality and equal protection before law. Along with that, it was read with Article 21, that is right to life and personal liberty. And they said that keeping drugs or using drugs, they wanted to say it was violating one's equality and personal liberty. But then the court had completely ruled out these two justifications that has been given by mentioning that the reasonable restriction, which is mentioned under Article 19 of the Indian Constitution, does not allow you to do so. So as I have mentioned that this is a very small act and it has to be read with the IPC and Constitution. So that's why it's very small. So yes, you can now proceed.
Madam, there are some queries to you. One query is that there are lots of de-addiction center, rehabilitation center that people are starting it without getting proper permission. No, they do lots of human rights violation also. It's not manned by medical professionals. Non-medical people, they start this rehabilitation centers and they, ill-treat the inmates. No, like does it come under the purview of our law?
Yes, sir. So I am very, it is very saddened to say that in India, we have a Human Rights Act of 1993, but it clearly does not mention all the points. And I would say there is an inadequacy of Human Rights Act in India as compared to the international community if we see. But yes, if any kind of illegal activities been found or anybody's human rights violations have been found, as I have mentioned, it can be brought under the law. It may not come exactly under human rights, but yes, under IPC also human rights activities have been strongly prohibited, and charge FIR can be filed. Within FIR can be filed, it depends on whether it's a bailable or it's a non-bailable offense. Depending on the cognizance of the offense, yes, the perpetrator would be put behind the bars and then now put next to the judge. Depends on the offense that they have been committed. As I have said, sir, in my thing, that why this needs to be prohibited, because as you have very well mentioned, sir, there is also an Immoral Trafficking Act, which has been there. Why? Because women are mostly vulnerable, children are pretty vulnerable, and what do? They use them to commit such crimes. So it is not only that only drug abuse crime has been committed. Apart from that, immoral trafficking is also being done together, sir. That has been found out, sir. There has been this Immoral Traffic Prevention Act of 1956, which was been recently amended, the bill in 2018, which like one offense is dragging another offense into it. Like it is like, how do I say, for example, if somebody is committing a murder, sir, it is not that only committing a murder. You are first doing a conspiracy, then you are preparing it. So conspiracy, criminal conspiracy is also punishable. Criminal preparedness is also punishable. So it brings a lot of charges together, sir. And depends on various other acts also.
Thank you, madam. Thank you for your time.
Ma'am, we have one more query, ma'am. When we get patients who are into substance abuse, when we take detailed history, if we get to know the source from which they are getting these drugs, illicit drugs, do we come under purview of law that we have to report it to the authorities, or?
Ma'am, as per anything, for example, even it's a drug is a very huge thing. Even if it's a road accident or a small accident or a domestic violence case also, it needs to be reported to the police. Treatment is with the doctors. That's a very noble profession that the doctors have. But the perpetrators cannot get away by doing it. So the report is very much necessary. Not only for this is a very, very, very huge, heinous crime. Apart from that, even if somebody comes or if anybody says that forcefully wants to abort a child, the in-laws wants to abort a child, or the girl's family wants to abort a child against the consent of the woman, at that time also they need to inform to the police about it. That is the responsibility. That has to be done.
Thank you, ma'am.
Thank you.
Ma'am, there is a question from Dr. Senthil Kumar in the chat box. When there is even capital punishment for drug trafficking in many countries, in India, are the offenders even given punishment in most cases?
In India, it is well mentioned. Capital punishment is for the rare of rarest cases. The prohibition is there, as I have said. Execution is way different from what has been written on paper. If we can very well see, for right now, the rape case that goes on, they can file curative petition in the Supreme Court. It takes years. In the Nirbhaya case, everybody wanted for the death penalty, but our law is so liberal that they can keep on appealing. They can file number of times of petitions. They can last appeal for the president's permission for giving them, and then only death penalty will be given. So yes, India does not give death penalty to that level as they should give to other countries. Yes, that's what I can say. India does not, because, and moreover, India, the cases are flooded. So if I get a date today, I would get a date probably 6 months, 8 months after, again after 6, 7, 8 months. So it is well said that delayed justice is denied justice. But then yes, death penalties are not given at such a huge level as it is supposed to be given. But yes, death penalty is there. And it has been well mentioned by various honorable Supreme Court judges that only in rare of the rarest cases where the crime is the most heinous crime, then only it will be given. And then also it depends if the person or if the perpetrator appeals, and if the higher court thinks that they may not give death penalty, maybe the lower court gives a death penalty, the higher court thinks it is not qualifying for a death penalty, then that will not happen.
Thank you, ma'am. Ma'am, there is one more query. Juvenile Justice Act is recently amended. Does drug-related offences by juvenile too or part of that act?
Which act? I can you just write it in my chat?
Yeah, Juvenile Justice Act.
Juvenile Justice Act. Yes, tell me.
Does drug-related offences by juveniles that also come up as a part of that act?
If the drug abuser is a juvenile, then yes. As I have said, there are many acts. For example, for me, a juvenile act is not applicable. But if the abuser or if the person by somehow has been connected to become or been misguided or forced or by misguide, coercion has been brought into this, is a juvenile, then obviously juvenile will be brought into it. For example, I do not want to I do not want to commit this offense, but probably people are forcing me. I can go up to the National Commission of Women for Women Rights violation, that being a woman, I am vulnerable, I am not allowed, I am not part of it, but I am being forced into these drugs. So along with this Drugs Act, I can also bring various other human rights, women rights act into it. Depends on case to case, who is the person who is appealing into it and what is the scenario. Every scenario is different from one another. Yes, as I can see, there is one thing that's written by Prince William, sir, I think, or Prince William, that judiciary is the biggest pending. Yes, now with COVID-19, we have so many pending cases. There are so many vacancies for judges which are not being filled yet. So yes, it is. That is why arbitration has been encouraged in India right now. That go for arbitration and let these cases. But again, fast track cases are trials will be also taken. Fast track courts are also being formed. But then again, it depends from case to case. Maybe Nirbhaya case, without humiliating anybody, keeping into the dignity of everybody. Maybe Nirbhaya case, maybe same kind of Nirbhaya case may have happened with some other woman, but maybe that the court was not, fast track had not happened to that level.
Good afternoon, madam. Yes, see, we commonly also deal with the family members of drug dependence patients. So in that case, the patients with drug dependence, especially alcohol dependence, cause severe physical violence to the spouse, especially the wife. Sometimes it happens that the wife goes and does manual labor and earns the money and comes, and the husband exploits and takes all the money from the wife and uses it. This is a common day-to-day occurrence. So how we educate them is that there is a Domestic Violence Act, there is Women Police Station. You go and approach them. They will take action against the party. So they go, and what the police maximum does, it comes and threatens the patient once, but no further action happens, and the patient and the person with drug dependence again comes and tortures the woman, and she can't file a divorce, and she doesn't have that much money to proceed with the law. What else can we educate the woman so that she can escape the person with drug dependence physically harming her and exploiting her financially? Can we educate something else so that she can use that way and help herself?
So, sir, with due respect, what you said is completely true. It happens, and we lawyers are not a part of it. It's the executory body which commits it. But coming to education, I think bottoms-up approach needs to be done. What is bottoms-up approach? Bottoms-up approach means where we start from the root cause. That is, starting from the villages. Sir, I believe, according to my little knowledge that I have, a little education may change, and women needs to be financially independent. I can see there are many persons where women are financially independent, but they're somehow attached to the family in such a manner that they cannot get away from it. In that scenario, I can again blame the society, because the societal norms are so rigid, so strong, that even if the women who is the sole earner of the house cannot get away. But then, sir, I believe with time, only this can happen, and with less of corruption. Otherwise, I do not see a future to this. That's the truth.
Thank you.
I don't see any future to that. It will still. And a question that has been given by Dr. Senthil Kumar: what happens to drugs which are seized by police and produced in courts? Any rules for destroying? I clearly don't have any knowledge of that. I clearly don't have. I'm so sorry. I may research, or I know a person who deals with drugs and everything. I may ask that person and can get back to sir, but right now I don't have that.
Ma'am, there is one more query in the chat box. Are there any new laws with regards to the opening of liquor shops in the pandemic situation? Which has again worsened the spread of the disease.
Absolutely, it has. Again, it depends from state to state. A state may allow, another state may not allow. Right now, there is a very difficult situation that we are. A state is allowing, another state is not allowing. So it depends from state to state. State laws. Again, the state laws, for example, I can say for Calcutta right now I am in, I definitely do not have knowledge of all the states that are keeping on changing. It somehow opened in West Bengal. After 7 days, they realized it is creating more number of cases. They have stopped it again. So it depends from situation to situation and state to state.
Okay, ma'am, thanks a lot for that enlightening talk, and special mention that I got to know that you are not well, and in spite of it, you have taken time to prepare and do this talk. Thanks a lot, ma'am.
No problem. Thank you. Thank you.
I hand over the session to Dr. Shivabhagya to give a vote of thanks.
A very good afternoon, everyone. On behalf of Department of Psychiatry, I, Dr. Shivabhagya, deem it a great honor and privilege to me to deliver the vote of thanks. I take this opportunity to extend our most sincere thanks to all the participants for making it convenient to attend the webinar. I would like to thank the pillar of our department, Professor Dr. Sabri Sridhar, who organized the webinar. Thank you, sir. I would also like to thank flamboyant women of our department, Dr. Shabiba Kailash, for chairing this wonderful session. Thank you, ma'am. We are grateful to Ms. Mrinalini Banerjee for having accepted our invitation and for sharing her knowledge on legal aspects of drug abuse and illicit trafficking. Today, even without the PowerPoint presentation, we were able to stay connected throughout the session just because of your eloquent presentation. You also sensitized us to laws and convention followed here as well as the abroad and other countries. Thank you, ma'am. Finally, I would like to thank all my department members for the overall support and guidance for the making this program a success. Thank you once again.
Okay, madam. Thank you. Thank you, madam. So with that, we'll come to the end of this International Day Against Drug Abuse and Illicit Trafficking. Thanks for everyone who have joined us in this program. Thank you, one and all.